So these are the people versus J.C. Owens. Can I get your appearance?
Yes, thank you, Judge. Andrew Mickus on behalf of Ms. Owens, P 76268. Ms. Owens would waive any objections to appearing via video today as well, Your Honor.
Okay. All right, did you speak with Mr. Zick this morning?
I did, yes, Your Honor. I think we've reached a mutually agreeable resolution to the matter. Ms. Owens is going to be entering a plea of guilty to one of the matters, and the court will be dismissing, and Mr. Zick will be dismissing the other matter. We didn't get specifics as to case numbers, but they are essentially identical. She would agree to any restitution amount. He did not have a figure before him. I estimate that that figure is going to be 0 because I believe all of the items were recovered in both cases at the time of the arrest. So I do anticipate that. But in the chance that I'm wrong and there is restitution, she is able to pay that today.
You know, it's always interesting how people sometimes suddenly seem able to pay for an item only after they've already been caught trying to take it. The timing tends to raise some obvious questions.
Are you pleading guilty of your own free will?
Yes, ma'am.
And Mr. Zick, I see you're back on this. Is there a preference for the people on which matter she should plea on?
No
I'm
preference.
just gonna plead. Okay, all right. So ma'am, back on, how do you plead to the charge of larceny?
Guilty.
Were you in the city of Taylor on January 31st of 2023?
Yes, ma'am.
And when you were in the city, did you go to Walmart?
I did, Your Honor.
And when you were at Walmart, ma'am, did you take some merchandise that wasn't yours?
Yes, sir.
What's wrong? Having trouble saying out loud what got you here in the first place? The reality is that all of this could have been avoided if the items had simply been paid for from the start.
Your Honor, I think she's stalling just because there was an attempt to do so, but because she didn't leave with the items. I did discuss with her the legal nuances between those and that there really isn't one. So, JC, do you understand the question? She's asking if you attempted to take any items for sale.
Attempted, yeah.
All right. Where was she stopped? Parking lot or as she was exiting the building?
Before exiting the building.
Or as you walking out of the building, Miss Owens?
I was going towards the door.
I think she had just left the self-checkout area and was heading towards the door when store security stopped her and initiated.
And were there items that you didn't pay for when you went through self-checkout?
I mean, I don't know how to answer that. Honestly, Your Honor, I left the cart. I walked away from it. I don't know how to. And then the other one was,
hang on, JC.
Wait, so Miss Owens, did you put property in your cart or in a bag that you didn't intend on paying for?
I mean, no, but.
Sounds like a not guilty plea to me. But simply leaving the items behind after being confronted does not automatically erase the earlier conduct that led to the situation. The key legal issue usually becomes intent and whether there was an attempt to take the items unlawfully, as the lawyer points out. The law can distinguish between a completed act and an attempted one, but an attempt itself can still carry legal consequences.
All right,
yes,
I can't accept the plea, then we'll get a jury trial date.
Your Honor, I'm guilty.
Your Honor,
no, you're not guilty. Miss Owens, you've been through this before. You've got a ton of larceny convictions, right? This isn't your first rodeo. And ma'am, you're not required to enter a plea of guilty. But if you think you're going to sit here, I'm talking. If you think you're going to sit here and tell me that you didn't do anything wrong and think I'm going to accept your plea, you're sadly mistaken. I'm happy to have a jury trial. I like nothing more than a jury trial. You either want to accept a plea or you don't. And you're either going to be honest to this court and accept responsibility or you're not. It's that simple. And if you cannot lay a factual basis for what you did that makes you guilty of this charge, I will see you on your trial date. Are we clear, Miss Owens?
Yes, Your Honor.
Darmam. Judge Shackelford clearly isn't interested in going in circles when there's a straightforward way to resolve disputed facts, a jury trial. If someone wants to challenge the allegations, that's exactly what the process is there for.
So what do you think you did, Miss Owens, that makes you guilty of larceny?
Your Honor, the first offense, I didn't scan an item, and honestly, it wasn't to steal the item. I tried to pay for the item.
All right, so that's a not guilty plea. So, okay, we're going to just go ahead and set these both for
But
jury
the second
trial.
one, I did intend to. So, I mean, yes, I'm guilty on the second. Yes.
You accidentally didn't scan $250 worth of items?
No, I didn't say accidentally. There was a computer or something
No,
wrong
on
with
the
that
first
scanner.
case, the allegation is that you stole 8 items worth $250. And you're telling me that was an accident?
Your Honor, I'm guilty.
That's not how it works. You don't simply declare guilt, you have to establish the factual basis for it. The purpose of that process is twofold. First, to ensure the correct person is being held responsible for the correct conduct, and second, to create a clear factual record so the matter can't be relitigated later on the same grounds. If someone disagrees with how the process operates, the appropriate response is to challenge it through legal channels, not to ignore it altogether.
We're going to jury trial.
Your
I'll
Honor,
set a jury trial date, and we'll see you on that date.
Your Honor, if I may have an opportunity briefly in a breakout room with my
No,
client.
I've had enough of your client, quite frankly, and the games she likes to play. She's lucky I didn't revoke her bond the first time, and now she wants to play with whether or not she's responsible of this or not. And no, I'm not comfortable taking a plea. She's made it clear she didn't do anything. We're all set. You'll get your jury trial date in the mail. We're all set, ma'am. I'll see you on your jury trial date. Thank you.
Ma'am, please.
You'll get notice in the mail.
I didn't.
Okay, so this isn't actually the end of the video. The judge is about to explain to defense counsel exactly why the plea can't be accepted in its current form, and gives them one final opportunity to speak with their client and clarify her position before the court proceeds further.
Mr. Mikos, I'm sorry, I'm not tolerating your client and her nonsense. We'll set it for jury trial. If you talk her into taking a plea that she can reasonably put on the record without being full of nonsense, I'll consider it. But for now, we're going to trial.
A few moments later.
All right, we're back on the record. This is the People versus J.C. Owens.
Yes, thank you again, Judge Andrew Mikos, P76268 on behalf of Ms. Owens.
Ms. Owens, tell me your name.
J.C. Owens.
Ms. Owens, did we go over your constitutional rights a minute ago? Do you remember those rights?
Yes, ma'am.
Knowing all of that, how do you plead the larceny?
I plead guilty, Your Honor.
Back on January 31st of 2023, Ms. Owens, were you in the city of Taylor?
Yes, Your Honor.
Did you go to Walmart?
Yes, Your Honor.
I want you to tell me what you did that makes you guilty of larceny.
I intended to steal items, Your Honor, without paying for them.
What items?
I think I honestly, I don't remember what items exactly, Your Honor. I think they were just normal, like condoms and stuff. Toiletries, yeah.
You see, it wasn't that hard to take responsibility for the situation once it was clearly laid out. Now was it?
Did you take them with the intent to deprive the Walmart of their property?
Yes, Your Honor.
And did you take those items and put them in a bag without scanning them at self-checkout?
Yes, Your Honor.
Are you satisfied, counsel?
I am satisfied, yes, Your Honor.
All right. I'm going to accept the plea as knowing and voluntarily given. The case ending in 230962. That case will be dismissed per the plea.
Oh my God. So you're on felony probation and still not managing to stay out of trouble for relatively minor offenses. You do realize that can be grounds for a violation, and that it could result in you serving the remainder of your sentence in custody.
Meet with the probation department for a pre-sentence investigation. You're going to get notice of that in the mail.
Okay.
And you're going to meet with them. And I'm sorry, Mr. Mikos.
No, go ahead, Judge. I'm sorry.
Yeah, I think we need an evaluation. So you're going to meet with the probation department, Ms. Owens, and they're going to contact you for a pre-sentence interview. After that interview, we'll meet again for sentencing. Are you still on felony probation?
JC, are you still on probation with Judge Matthews? Yes.
Yeah.
All right, guys. That's the end of the video. In the end, it looks like she managed to get to the point where she acknowledged responsibility for her actions. If you enjoyed the video, leave a like. If you didn't, leave a dislike. Either way, drop a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out. We're so close to 100k subs. Stop being stingy with that subscribe button.
Okay. All right. Well, I'm assuming a lot of things will likely run concurrent, but I want my probation department to at least look at it. And Mr. Mikos, I can't give you a sentencing date because I don't know how backed up they are on their PSIs.
I understand.
So it'll be a Wednesday, and we'll get it out to you in the mail as soon as they meet with her.
Okay. We're probably talking a few weeks out.
At least, I think generally 3 to 4.
Okay.
And bond conditions will just continue until that time.
Sounds good. Thank you, Judge, and thank you for your patience today.
All right, I'll see everyone at sentencing. We're all set.